in. Okay, cool. I started recording as well, so in case one of them messes up, that will be good.
Okay, got a PowerPoint presentation here I want to go over. It's very important. It's kind of boring stuff because it's federal regulations, but it's very important to your business, so recommend paying attention. And if you got any questions, go ahead and just put them in the questions box. If there's something that you want to go over in particular, just let me know. And I've been doing nothing but reading this thing for the past week, just making sure that everything's up to speed. Okay, so let's get started. The new TCPA rules are dropping October 16th, like I mentioned, and this presentation is by Rich and the Squeeze Moby team. Okay. Important in doing TCPA regulation overviews is going over the different details of the terminologies. I do this every day. I actually have a 9-to-5 job as well. I do this every day as far as briefings. So we've got to go over the terminologies, make sure we're on the same base. So let's just go through it. What is the TCPA at all, in general? It's the Telephone Consumer Protection Act. It's not something new. It's been around since the 90s. And we'll get into details on the detail pages here. What is telemarketing? What is auto dialing? What is robocalling? What is SMS? And what are the rules in detail? And I know you know most of these things. We've got to come to a basic understanding so that you can see how they all get impacted by the TCPA regulations. Okay, TCPA, what is it? Okay, like I said, it was passed in the 90s, 1991 as a matter of fact. The FCC is in charge of the TCPA, and they actually manage both the rules and the regulations for implementing the TCPA. So among other things, the TCPA allows individuals to file lawsuits against business owners that send out SMS messages because they're receiving unsolicited telemarketing calls, unsolicited faxes, pre-recorded calls, and auto-dialed calls. And later on in the presentation, we're going to get into detail between the difference between auto-dialed and manual dialed, because it really only pertains to auto-dialed. Okay, so what is telemarketing in general? Okay, these are the calls that include those made by advertisers that offer a product for services, products or services to customers. They're purely informational calls that are non-commercial are exempt from the TCPA regulations, and that's an important distinction. If you're given an information thing that you're not generating revenue from, it doesn't qualify as a telemarketing call, but it is a telemarketing call if they're trying to sell you stuff, of course. Okay, what is auto-dialing? Okay, there's a distinction between obviously auto-dialing and manual dialing. An auto-dial call is a phone call involving a live person or a pre-recorded message that is placed using an auto-dialer or automatic telephone dialing system. So obviously anything that stores a number or has a name associated with it and just auto-dials people out without their consent, that's a big deal for the TCPA regulations. We're going to get in detail with that as well with the rules. Okay, here's the thing with what if you're not sure whether you're auto dialing or not, think that you are. It's safer to be considered that you are versus you're not, so you can be covered by taking certain steps. They should probably be construed as being an auto dial call in an effort to avoid unwanted litigation and regulatory action. If you're using any kind of software, such as the SMB backend, you could be in jeopardy of getting fined. So we need to go in detail on like how to cover your butt. And as a disclaimer here, always, if you're in doubt with any aspect of your business, consult an attorney. It's better to consult an attorney up front than trying to hire an attorney by a case later. So just be smart about it. I've got to do the same thing in my business. Let's talk about what a robocall is. A robocall is a phone call that is like an auto dialer, but it delivers a pre-recorded telemarketing message, such as SMS messages, such as, hey, those threatening calls about the FBI has noticed a crime thing in your area. Please contact us for security. That's a pre-recorded message, right? And in particular, SMSs, the question is, are SMS text messages to cell phones considered calls under the TCPA? Definitely. They're both voice and short message service. SMS, text messages, if they're transmitted for marketing purposes. There are some things that you can do that do not qualify as marketing. You can do political, sponsored messages and some other things, but make sure that you comply with that. And here's a very detailed case. The TCPA has interpreted in recent years to prohibit the sending of unsolicited commercial text messages to cell phones with limited exceptions. Of course, you get the SMS messages, you get the alerts, you get the presidential alerts, you get the, whatever they call them, code blue, code red, alerts for weather. Typically, you subscribe to them and you typically get messages back. Actually, I'm not too sure how that's going to change on some of those services because some of them are privately owned businesses, and they will have to get your consent, explicit consent, to receive those messages from them. Okay, now the fun stuff. Here's the rules. Okay, effective October 16th, 2013, there is a new rule, prior express written consent. Okay, so here we get into like the terminologies. Unambiguous, which means explicit, not inferred, not anything like that. Unambiguous written consent required before a telemarketing call or text message. And there is an exception. Calls that are manually dialed, unlike an auto dialer, do not contain a pre-recorded message, are exempt from the TCPA. We do a lot of auto dialing here, so we do have to go through and get explicit consent from our customers. Also, there is no more established business relationship exemption as of October 16th. What does that mean? I'm also a real estate agent as well as an internet marketer and software developer. So as a real estate agent, it doesn't matter if I have an established business relationship. That no longer receives advertisers or prior unambiguous written consent requirement. So what that means is even if they've talked to me and say, hey, yeah, I want to get an SMS message, that's cool, that doesn't count. They've got to have express thing. You've got to put it in your files. You've got to store it in case you get audited. And if a complaint comes up, no, here's the documentation that we've got that says we can contact that person with an SMS message. So that's part of the rules. We're going to continue on with some of the rules. Are SMS messages to cell phones considered calls? Yes, still, of course. But beginning October 16th, 2013, prior express written consent will be required for all auto-dialed and pre-recorded calls, texts sent, made to cell phones for marketing purposes or residential landlines for marketing purposes. So we really don't get into, with the SMB backend, we really don't get into the pre-recorded messages. But things, if you deal with like CallFire or something like that, like I do, I've got to make sure that all of my customers and clients that I've got have to sign a piece of paper saying they know that they're going to be receiving SMS messages and that they consent to these messages and also how to get out of those messages. Continuing on, rules are still compliance with the e-Sign Act satisfies the previous slide requirement, meaning that electronic or digital forms of signature are acceptable. Go ahead and check out the details on the e-Sign Act. What you can do is set up an agreement or a consent via email, website, text message, telephone key press, or voice recording. So just if you're in compliance with that, then you're like compliance with the TCPA stuff. Okay, and going back to drill this home, consumer consent must be unambiguous. Very fancy word, right, for making sure that it's declarative and explicit and they know what they're receiving. Okay, meaning that the customer or consumer must receive a clear and conspicuous disclosure that he or she will receive future calls that deliver auto-dialed and or pre-recorded telemarketing messages on behalf of you. That the consent is not a condition of purchase, which means like, to purchase something from you, they don't have to, opt into your SMS list explicitly. They can still purchase your product without it. And they must designate a phone number at which to be reached, which should not be pre-populated by the advertiser in an online form. So go ahead and, let them supply that to you. Limited exceptions apply to this requirement, such as call text from the consumer's cellular carrier, hey, you owe us a bill, here's your minutes, etc. like that. Debt collectors, Not sure how they lobbied to get that, but that's awesome. If you owe money to somebody and they sell it to somebody else to collect that debt, you definitely can receive those SMS messages. So maybe consider getting the debt collection business. Schools, for any reason, I guess, student missing, etc., and also healthcare related calls. Okay, continuing on. Okay, so if a consumer complains to the TCPA under the TCPA regulations and files a complaint against you, it's called a dispute. And if a dispute arises, the advertiser, the advertiser, bears the burden of proof to demonstrate that a clear and conspicuous disclosure was provided. It's not on the consumer. They made the complaint. They don't have to prove anything. They just say, hey, this guy SMS'd me. I didn't want that. I'd like to sue him, or file a complaint. The TCPA will come to you and see, hey, where's the documentation for this person getting signed up for the regulations? And if you can't provide it, you might want to consider hiring a lawyer at this time after the fact, because they're going to come after you. And there's also a difference, and I think is it on this slide? It's on the next slide, I think, but it's going to get into the severity of punishment, depending on if you willfully and voluntarily disregarded the TCPA regs, or if you just didn't know it and you kind of messed up. That they treat different cases differently, but obviously plan for the worst. Okay, it's best practice for advertisers to maintain each consumer's written consent for at least 4 years. That's crazy, but I mean, you're going to have thousands of pieces of paper in a filing cabinet or wherever you store them. It's the federal statute of limitations in the U.S., and that is the limitation for them to bring action against you on the TCPA. And so that 4 years, is a trailing 4 years. Every month you've got to go through and choose to purge that 4 years and 1 month documents. So it's actually an expense on you, a burden on you to maintain these records and dispose of the records. Okay, evidence of internet-provided written consent includes, but is not limited to, website pages that contain consumer consent language, associated screenshot of the consent web page as seen by the consumer, where the phone number was inputted, complete data records submitted by the consumer, together with the applicable consumer IP address. So you've got to track all those items to be compliant with the TCPA rules. That's pretty intense. That's a lot of data tracking. That's a lot of overhead, but it's what we got to do. It's kind of like taxes now. You got to do your own work on taxes to being compliant with the IRS. You got to do the same kind of stuff now for the TCPA. Okay. In detail, beginning October 16th, the established business relationship exemption for pre-recorded telemarketing calls to residential landlines will be eliminated. What that means is, like, I've got buyers and I've got sellers. I can't, because I've got a prior business relationship, I just can't send them an SMS that's realtor related. I've actually got to get their consent to make sure that they know that they're going to be receiving these messages. Now that also applies to auto-dialed numbers. If I'm texting somebody and I type in their number and I say, hey, I've got some updates on your property, that's okay. It's not auto-dialed. But if I've got something that's just spamming them with something that they didn't want and didn't consent to, then you're in violation of the TCPA regs. Okay. In the past, advertisers could rely on an established business relationship, such as a previous purchase, to circumvent the need to obtain a consumer's written consent to receive telemarketing calls. That's no longer the case come October 16th. After this year. Written consumer consent is required, even if they had a previous business relationship. This is just harped on. You can't say, well, I was doing business with them, why can't I send them an automated SMS? You're just going to get a ding for a bill to pay that for each an individual SMS message that you send out. So it's best, like, again, be safe than sorry. Okay, before we get into the penalties, let's take a look at the questions real fast and see if there's anything there that we need to address. Popping that out. Okay. Question was, should we care in the UK or is this strictly USA only? The TCPA is a federal US regulation, but if you're doing any kind of business in the US, it doesn't hurt to start doing that. If you're just strictly UK, definitely I would check with the UK laws. I've never really seen something like this happen that doesn't happen elsewhere. Actually, I thought Europe was more strict about that stuff. And when do we need to publish these new rules to stay compliant? Not too sure what you mean there exactly, Cliff. These happen. You've been prior notified by the TCPA regs, so they consider that notification on their website. So October 16th, you got to be compliant. October 16th, like how many days is that from now? 2 days from now. Is this applicable to the UK? Not that I know of. You might want to check with the UK rules. And do we have to get existing SMS customers to re-opt in for compliance? Definitely. Not just re-opt in, but give exclusive consent for you to send SMS messages to them. It's not just, hey, opt in again. You've got to either handle it through the e-sign, through the website, and you got to track those records and store them for 4 years. It sounds like this is going to conflict with the UK Data Protection Act. Sounds good. I have no idea about the Data Protection Act, but I know that UK and the Eurozone is typically more stringent on these rules than US. US is like catching up with more litigious stuff. Am I going to give examples on how to get consent? Yes, at the end of the presentation. So we cannot sign up somebody using the QR code unless we get their signature. Definitely, you can get them on the list, but you can't send them an SMS without them signing that they consent to that SMS message. Again, if you've got any questions about your business model, I would definitely get with a lawyer and just be safer than sorry, because a $300 lawyer bill just to take a look at what you're doing versus fines that are coming up in the next slide. It'd be cheaper to do it up front. Okay, that's all the questions we got in the questions box. Moving on. Okay, we got one more question. If we do this on behalf of our clients, do we both have to have the written consent? That's actually a really good question. If you've got a client relationship, that means that you're doing business as their agent. So that is, you are them if they're the clients. There is a distinction between customers and clients in the real estate field. So if you mean literally clients, you are their agent. So as long as they have a record of it, I would recommend that you also get a record of it, just in case there's any disputes. You wouldn't want the client running off with those records and then you left with accusations of, hey, you don't have these documents. Hey, we're going to go ahead and come after you. That would not be smart. I would definitely get copies of that. Is this a one-time requirement, or do we need to send reminders from time to time? As long as they've got explicit consent, that is good until they explicitly decline consent and they want you to take their information off of there. So yeah, then you'd have to re-fire it up again, but no, it's not periodical as far as I could read. Okay, that concludes the questions. Continuing on to the penalties. Are the penalties pretty stiff? Well, it depends on your definition of stiff fines. I would say yes. To me, it's business crippling, actually. The TCPA provides for either actual damages or statutory damages, ranging from $500 to $1,500 per unsolicited call or message. You send out 50 of them, that would destroy me if I got anything like that as a fine. Going back to the questions real fast, do we have to end all messages with the reply stop to end? Cliff, we can go ahead and talk about that later. I'm not too sure about the stop to end thing. I would recommend getting their consent before sending out another one, unless you've got other messages about to go out. Okay, back into the penalties, in determining the final amount of statutory damages to award, here's what I was talking about earlier. If the defendant, which is you, willfully or knowingly violates the TCPA, you're going to be charged the higher end of the $1,500. if you just kind of made a mistake, somebody complained, you accidentally sent it out the wrong way, it was automated, it was auto-dialed, you might get $500, or you might even get a warning. But again, make sure that your business is in compliance. There's nothing we can do about this. You know, you have to comply. And what I was talking about earlier with E is that check this out. You're up to speed a little bit more than just about anybody else on the TCPA at this point. You now have a market differentiator between your offerings and your competition's offerings. You know that this thing exists. You know what your customers and clients can be in trouble for. Now, with that knowledge, you can go in there and say, hey, you know, you're going to be protected by us being in compliance with the TCPA/e-sign. But go ahead and, you know, make sure that when you approach the next customer, hey, we're on top of this TCPA stuff. It can cost you thousands and thousands of dollars if you're not in compliance. We are compliant, and we'd like to sign you up for our service. And you know, you are now ahead of your competition. I think the 39 people that are here joining the webinar today. Okay. So somebody asked about the consent language. Definitely wanted to find that for you. Again, contact a lawyer if you need assistance. This is not legal advice. This is us trying to provide a service to you guys and girls. Make sure that you've done your due diligence. So let's read this over. I hereby consent to receive auto-dialed and or pre-recorded telemarketing calls from or on behalf of you at the telephone number provided above. I understand that consent is not a condition of purchase. And again, that just means, you know, they don't have to sign up for your SMS for you to sell them a product, for you to sell them web design or whatever, a food product. So that's pretty much it. That's your consent language. I can actually copy and paste that into the chat box. And again, if you've got any questions about this type of stuff, consult a lawyer. That's the critical part. We're going to send all. Okay, I post that in chat. Moving on, go into the disclaimer for this whole presentation. You're the business owner. Be smart. Do your due diligence. The material contained is just advice to make you aware of what's going on. It's a radical shift in our business model. Typically, you just say, hey, sign up. They sign up. Next thing you know, you're doing business. Now it's like sign up and track and manage those documents for 4 years. The material contained herein is provided for informational purposes only and is not legal advice, nor should substitute in obtaining legal advice from any attorney. Each marketing situation is unique, and you should not act or rely on any information contained without seeking the advice of an experienced telemarketing attorney. Okay, so really, this is a big deal. It's happening in 2 days. Get on it. Make sure you're doing your documentation, making sure that you're getting your consent, and you're ahead of the game. People, you know, they're starting to get fines. You don't want to be the example for your competition to be like, yeah, we don't want to be like that guy. We have to implement that stuff in our business for the real estate, and it's definitely not fun. Okay, going back to the questions on the TCPA stuff. Okay, yep, again, just on the UK stuff, go ahead and check your, actually somebody wrote that up there. Look up the UK Data Protection Act if you're from the UK and see if this is impacted at all for the UK side. Okay, that really concludes the presentation of the TCPA stuff. I have to comply with it as well, so if there's any questions, just hit us up. I know it's not fun.
Cool.
Yeah, I know it's not fun, and I know you got to deal with it, and so.
Cool. Yeah, if you could take some of the questions.
Sure.
And let's see, and then yeah, we'll wrap it up. And I think it's been very informative. Yeah, like you said, I mean, it's not the most exciting topic, but I thought And I know you were saying that as well, because we received some support tickets that it was something important to address. And of course, I want to put the disclaimer out, we're not lawyers, all right? So this is for your information and for you to become more educated. But of course, we have to put that disclaimer out like everyone does, and meaning that, even though we're giving advice, we're not necessarily responsible for anything. But yeah, I think Marcel, if I'm pronouncing it correctly, said, hey, can you make these slides available? And I think we can do that. I think that won't be a problem. Rich, maybe if once you maybe upload it to like Amazon S3, if you could do that, then we could send it out through basically the Squeeze Mobiliaire list.
Sounds
to
good.
everyone that's a Squeeze Mobiliaire.
I'll do that today.
So yeah, check your email, and it's gonna be, I know you guys get a lot of emails, but check your email, because we will make that available, and also along with the webinar recording.